Hello. I'm just going to give you an update on my case today against Jacobs Enforcements. So I've already put out that the case was struck out and there was a cost order put against me, which I won't be paying. And basically, it was a little bit of an embarrassment. So first of all, I want to say thank you to Wayne Layton for coming as an observer. It was great to have him there and he was able to give me some feedback after. Our last message, I think, ended in lol because it was embarrassing. And Robin Hood, I want to give a shout out to Robin Hood, Blue Ball, who has helped me get here. Now, he said to me a few weeks ago, how big are your balls, Vic? And I was like, yeah, okay. Why don't you just go all in instead of just flaking around the issue? We know that there's a huge issue here. And I was like, yeah, you're right. So let's go for it. So that's what I did. So a big, huge thank you to Robin Hood for giving me the courage and the knowledge and the information over the last 15 days to be able to bring this and live in my power with it and not live in any fear. So that was really enjoyable. For me, it's not about winning. It was about bringing the truth. So in this instance, I now know that the courts were corrupt. And people say that, but actually to walk it and see the corruption is something completely different. It did overwhelm me. I was a bit like, holy hell, it's true. Like there's a difference with someone telling you and you walking it. So I just needed people to know that the case that I had against Act Credit Management is a debt collector. This is an enforcement agent and they're regulated differently. They're regulated by the courts. But I was willing to give it a try and see how we got on. So just to let you know, Jacobs Enforcements contacted me on the 15th of October, out the blue, and said, we've come in for money, £601 for a liability order issued against you. At that time, I'd had my data breached by the hospital, so I was feeling really, really wobbly that all these people had my data and I'm the data subject and nobody should have that information. So this was the letter I received from Jacobs and it said 601, it's got all my exhibits on it because it's been in my bundle. And then a liability order was issued by the magistrate courts for £601, and that's what was their instruction. I've got my instruction, I'm now going to enforce the debt. Let's just go back to the beginning, where I received a district magistrate court summons for liability order on the 12th of September. It says here, you must not attend, and then it says here, you must attend. So huge irregularity there, but that's quite clear, isn't it, that it's a summons for the district magistrate court, not on any court paper, obviously, just a piece of paper. So I then get sent the liability order hearing, that the hearing went ahead at Plymouth District Magistrate Court without me, of course, no human rights there. And this is the liability order that the enforcement agents are reliant upon when they come to your door. So that's what I had in my bundle. And I've got a memorandum of entry to say that I was in the courtroom on this day, by the way. Victoria Rickson in here somewhere. Absolute little toff, which is the word the judge used today, by the way. He didn't give a toff about me. So I'm using that word, toff. What an idiot. So memorandum of entry entered in the register in the Southwest Devon district. It says here that that was the entry where I was entered into the system, the court system, that I was at court that day and I didn't turn up. So that's pretty much the basis of everything that I was bringing. Now, there was two roads I can go down. Straight harassment and no proof of authority, which would have been easier. But this is Victoria Rickson. She doesn't do things easy. She likes to unpick it all. So what I then realised was when I submitted my bundle on the 15th of May with the help of Pete Wilson, which was amazing, I wanted to push it a little bit. I wanted to push it and see, well, how big is this issue? It's actually not just Jacobs. Without the enforcement of with the liability order, the council needs to be there, and behind the council is a magistrate. So I'm like, well, they're all in on it, so really I should put them all in the bundle. So lovely Terry helped me for maybe about the last 15 days to get this bundle ready. Now, I will point out to you, here is my witness statement that I used today, okay? My witness statement was this is all the harassment from Jacobs. Every entry is pretty much harassment from them, and I've only been under them since October. From October to sort of down to here, I was receiving 1 contact a month, and I was then getting, from the 22nd of May, 1 contact every day, and sometimes 3 times a day, up until my bundle was due in, because they were trying to sabotage the witness and not give me a fair process. I put in the witness statement that I had persistent unwanted contact, that there was surveillance and intimidation because they filmed me at my house, significant psychological distress, coercion and blackmail, and stalking type behaviour. So that was in my actual bundle today. So when I submitted my bundle on the 15th of May, I then resubmitted a second bundle, which is this puppy, this humongous document, which is in 2 sections. There's 233 pages of sections 1 to 26, which is all evidence-based on every single law that is broken around the issuing of a liability order. That's all I focused on. Okay? Then in the next bit was my particulars, my witness statement, and all my exhibits for evidence today. So bringing the claim as the claimant, I'm asking the judge to listen to my case, listen to the defendants, and then come together with an answer. That's what I was asking for. So I started, the court was 15 minutes late. Sorry, my dog's whining again. Albert, out. The court was 15 minutes late. It was on Teams. And when I got on, it was myself, Wayne Layton, there was a clerk, a district judge, and the defendant's counsel, barrister. And within about 3 minutes, the clerk left. Yes, left. Now we all know what that means. So that happened. So the clerk left the room. Then the judge went to the bundle. Oh, there's a lot of information here. I need to put it all together. It's all fallen out, la, 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 la. And then he came to me and he said, Mrs. Rickson, I would like to give you the opportunity to answer this question. And he directed the question at me. And I thought, no. I'm not jumping your hoops, buddy. I'm going to write what I've written. I said, Your Honour, I'd like to stay in lane with what I've learned as a litigant in person because I have more rights. So I just started saying that Jacobs Enforcements, under the witness statement, had persisted unwanted disproportionate contact every single day on the run-up and during my evidence collection and printing. So every time I printed it, they then did more contact, so I had to reprint my bundle, and it was just such a stressful time. So it was to sabotage me. They were trying to sabotage any chance of me having a good bundle. Now, under the court proceeding rules, that is against the law. That's unfair, and under Article 6, I'm entitled to a fair trial. So I really did home in on that, and Wayne Layton said I gave a bloody good argument on that point. So I mentioned that a person who pursues a course of conduct in breach of Section 1 is guilty of an offence, and a person who is guilty of an offence if the person pursues a course of conduct in breach of Section 1 amounts to stalking, and if the person course of conduct is causes another person to fear, or on or at least 2 occasions that violence will be used against them, is a guilty offence. So I went down those roads. I could see the judge was getting a little bit like, no, I don't want to answer these questions. He was getting a little bit, let's be honest, this case didn't even last 45 minutes. It was ridiculous. So I was trying to go in with the fact that under Exhibit B, I, J, M, N, and P, that the defendant proved they had my data, and that the defendant says on their website that they treat people with dignity and respect. However, I have been treated like this in this case, 14 contacts in 14 days. He actually admitted, I didn't hear it myself, but Wayne Layton has said, he admitted it, he actually admitted that's quite a lot. So he actually admitted that that was quite a lot, bearing in mind what I just told him. And I said that the liability order that was issued by the magistrate, and the defendant has confirmed it was issued by the magistrate courts. He then said, Mrs. Rickson, we are not here to talk about the liability order, blah, 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 blah. I would like to go to Mr. Russell and he can speak. And I was like, what? You just shut me down halfway through my evidence. Like, what the hell? And then I was like, right, this is the bit. I need to regain my confidence. I need to regain that, hold on a minute. I'm entitled to a courtroom. I'm entitled to a justice system and the right to have a fair trial and law. I'll let him have that, and then in a minute I won't let him have that. So Mr. Russell ranted on, as he did last time, why they shouldn't, and under whatever schedule they are allowed to enforce their debts fairly, and they can harass me as much as they want as long as it's between 9 and 5. I then interrupted, I think, because obviously I had a lot to deal with today. I can't remember the full exact layout of what happened, but then basically what happened then was I said to the judge that it was disproportionate, because before the court hearing they were only contacting me once a month. Now they were contacting me on the run up to the hearing and the run up to the evidence bundle once or twice or 3 times a day. That's ridiculous. So he agreed it was a lot, but he said, oh, but the defendant said that they're allowed to do that in their time. And I'm like, what are you saying, Your Honour? Like, listen to what you're saying. So obviously I said that the enforcement shouldn't be disproportionate. They should not be allowed to be disproportionate in their policies. Then I wasn't allowed to touch on GDPR at all. Couldn't go near it. And then all of a sudden it got a little bit heated. Sorry, my dog is whining. In your bed, please. It all got a little bit heated and it all got a little bit intense, and then I might have lost my way a little bit because I got a little bit frustrated. The judge stopped me and told me, no, this is not a courtroom to discuss the liability order. And I said, the liability order underpins every reason why we're here. If the liability order had been issued, simply provide it properly. The properly executed liability order, provide it, and then you can enforce your debts. However, he didn't want me to touch on that. This courtroom, you've not brought this in your proceedings. He's right, I didn't bring it in my particulars, but I didn't want to bring it to my particulars because I was going to ask him to take this part to another hearing because I'd unearthed some evidence. And I said to him, I'd left my job, I was unemployed, Anyway, I proved in my documentation that Sean E. Jones, in a Freedom of Information 87871, stated that no third party deals with issues of liability orders, and a liability order is generated by a software owned by the council, and she is head of legal services and professional at HMCTS. When I read that out, the judge got well annoyed. And then I said, no, Your Honour, I'm not finished yet. I said, if you could go to, I didn't even get the page numbers in, it says in the council tax handbook that a liability order was removed from law on the 10th of July in 2003 in Wales and the 1st of October 2003 in England, and no form has been substituted in its place. Without any record of its order or judgment being issued by the court, an order from a magistrate court may be invalid. I then read out this from Sean E. Jones, a Freedom of Information on the 1st of February 2004. The deprescription of liability orders took place in 2003. It's there. She is head of legal and professional services at the HMTCS. Guess what? He stopped me. Stop there, Mrs. Rickson. Mr. Russell, can you please inform me about the liability orders? And then they started having a conversation. It wasn't even a cross-examination. It was a conversation that, yes, Your Honour, the council's send the liability order under the Court Civil Proceeding Rules 12.26 are allowed to give this. I had all this argument in my evidence that it's not in law. It doesn't stand up in law. They wouldn't let me speak. So I listened to Mr. Russell and I was shaking my head. No, that's not right. No, that's not right. And I'm not allowed to speak. Now, I did speak over and then I was stopped. And then I was threatened that I would be muted because this was on Teams, remember? It wasn't in a courtroom. Then I read out, Your Honour, I'm going to read this out, I'm afraid. Council tax liability is governed by the Local Government Finance Act. Now, he sat back in his chair and he was like, he's looking annoyed now. And the Council Tax Administration and Enforcement Regulations 1992. Liability orders were historically granted by magistrate courts and issued using a prescribed Form A. On the 1st of October 2003, Form A was removed from the Council Tax Handbook Regulations 2003 under the Statutory Instrument 2003-2211, and no statutory substitute was provided. And there is no legal prescribed form for liability orders. I then proceeded to explain to him, because I had to rush through my evidence now, that under the Local Government Act 1888, section 78.3, which has never been repealed, stands up today, says the local council shall not have power to make presumptions or to issue any judicial document or to exercise any judicial or quasi-judicial authority. I then reiterated Sian Jones, of the head of legal at HMTCS, wrote in 2024, the court is not to issue liability orders as these were removed from court and law following the amendment in 2003. Any continued use is not supported by current legislation. He was like, Mrs. Rickson, you have not brought the liability order in your particulars. What's removed from law, Your Honour? Why would I bring it? It's been removed from law. And that underpins my whole case. How can Jacobs enforce something that's been removed from law? There's no need to argue it, Your Honour. They shouldn't be at my door because they don't have the law that supports them. Basically, well, that's it, Mrs. Rickson. Stop talking. I've made my decision. Your case is going to be struck out. I said, what? My case is going to be struck out? Are you serious? I was like, what? I'm on the target. When I was on the target, I was starting to realize I didn't even get to my Attorney General statement at the back. I was well annoyed. I'd gone through this all day. Anyway, I said, Your Honour, you're being that's ridiculous. He said, well, you. I said, I have just proved to you that I've been harassed. You have not put in your particulars of claims schedule 12. Paragraph 26 of the Courts Tribunals Enforcement Act. He's correct, I didn't. But I did email the day on Saturday on the 6th asking for that to be added. Because of all the harassment, I missed that bit off my particulars. Now, I don't even need to put it in because I'm not arguing that. I'm arguing that it was removed from law. So you cannot enforce something that's been removed from law. Makes sense. So then I was thinking, what's happening? What do I do next? I didn't envisage this bit. It was a bit like this. Then I thought, right, I've got him. He's annoyed. He's flustered. He was so, I'm making my order. I'm going to strike up this claim. And Mrs. Rickson, I will put you on mute if you don't stop. And then he asked the clerk to put me on mute. And I said, she left at the beginning of the meeting. So she'd gone. He couldn't put me on mute, so I put myself on mute. And then I decided to type in the, Albert. Then I decided to type in the message on the side, I'm still here, and Your Honour, I have presented enough evidence for this not to be struck out. There's 335 pages of evidence that the liability order was removed from law, which means Jacobs Enforcements cannot come to my door under that order because they're removed from law. So how have I got a magistrate liability order if they're removed? Which magistrate has signed this? Or is it the council? It's irregular, Your Honour. There's no transparency. Anyway, the judge then said, Mrs. Rickson, you're getting a cost order against you for £4,000 or £5,000, whatever it bloody was. Not that I care. I'm not even worried about that. It's just a threat. And he said, well, what do you have to say about that? And I was like, well, I'm bloody unemployed with 3 kids. Are you telling me that I haven't, what? And anyway, I let them rabble on. And then, this was interesting. He said to me, because I didn't bring that schedule, I asked him as a litigant in person, can he provide me with some leniency with all the harassment that happened, that I missed it off inadvertently? And he said no. So for me to have had that added on today meant I would have won, but he wouldn't add it on because whatever reason, I don't know. However, I did have on my particulars harassment, and Wayne Layton said I gave a bloody good case on this. I provided that there was a huge amount of harassment and it was disproportionate. So when he made his order of 5,000, whatever it was, and I'm making an order, and he actually wrote that the claimant should have the damages. And I was like, oh, keep that going, but the defendant picked up on that. And then as he finished, I then said, Your Honour, I'm sorry, can you just explain why you're striking out the claim, please? I'm really confused. He said, it's not got any prospect of winning. I said, what? I said, that's 300 pages of evidence, Your Honour. I've boxed everything in. There's no way out of this. You cannot enforce something that's been removed from law. It's that simple. So they're enforcing something that's void. Mrs. Rickson, I am the judge in this courtroom. You will do as I say. And I was like, all right, whatever. Oh, I'm not scared of anybody. I'm not scared of you. I'm not scared of anybody. It's not about that. This is about the truth. The truth. So then I proceeded to poke him a little bit more and said, Your Honour, okay, you're throwing out the rest of it, fine. Surely you can now address the harassment that is in the particulars. And then he already made his order, but then he went, counsel, what's your thoughts on the harassment? What is your say? And I thought, why are you asking his opinion? You're the judge. You're the judge, and you've told me it was too much. You've told me that you agreed it was harassment. So he asked the council for their opinion, and they said that that they're allowed to enforce their debt whenever they want, as long as it's between 9 and 6 or 9 and 5, whatever it was. And I was like, yeah, oh, wow. So I said to the judge, are you agreeing, Your Honour, that they're allowing them to harass me? And he was like, I never said that. I was like, but you're striking it out. Why? That part has a prospect of success. You don't need to strike that part of my claim out because it is in the particulars. Guys, he wasn't having any of it. He put his foot down. He was like, no, strike out for the whole claim. It's got no prospect of winning. Even though he admitted I was being harassed, even though we had case law, and I said you were ignoring the case law. And then I asked him if I could appeal. And he said to the lady that was in there, the clerk, can you set up something for an appeal? And I said, she's not in here, Your Honour. She left. And then I said, so can you tell me how I appeal? And he said, you appeal, but in my opinion, I'm not allowing you to appeal. And I was like, you can't stop me appealing. So basically, I then reiterated, Your Honour, I have brought to you today a case against Jacobs Enforcements. They are enforcing debt based on a liability order that was removed from law. I have proved it through this bundle that then incorporates into the GDPR, the Harassment Act, the Data Protection Act, the European Convention of Human Rights, the Human Rights Act, all of it. And you're striking out my case when you know fine well it does have a prospect of success, but you're telling me it doesn't. I could get you if it was procedural. You're saying parts of it are procedural, but parts of it weren't. And he struck it all out. Slapped me with a cost order. So I've come away and I had a little cry because I was really adrenaline rushed because I was like, something took over me and I was like, I am not having this injustice. I really gave it my all, respectfully and the best I could with the tools that I had. I've since come away and realised that, one, it shouldn't be online. We know that anyway. 2, I can't find the judge anywhere on the judge's roll. Should we just have a little minute to think about that? 3, the clerk wasn't present the whole time. 4, he asked the council's opinion, the other side, on what they should do, what his opinion should be on harassment, and then threw out my claim. So I've learned a very valuable lesson today. It's time. We all have to club together against these corporations in groups. If you have been subjected to Jacobs, we need to form together and we take it out of the county court. It doesn't need to be heard in the county court. This isn't about the money. This is about dismantling this system. It's so corrupt that the judge today, I said to him, I hope you feel good. I hope you feel good. And he goes, I don't give a tosh what you think. That's what he said to me. I said, you haven't heard my claims, you haven't heard any of my evidence, you've shut me down, you've silenced me, da-da-da-da-da. And he just went, Mrs. Rickson, I don't give a toff. Wow, what a judge. I said, I hope you sleep well, that you've just given a mother who's unemployed, not working, with 3 kids, you've just slapped me with a cost order. I really hope you're proud of yourself, Your Honour. And the claimant, the defendant then started waffling on that they're entitled to harass when they want, they're entitled to do what they want, and this only proves that this is a deeply embedded systemic corruption using liability orders. We all know they're corrupt. We all know that. I was just trying to, for myself, validate how corrupt it really was, and I proved that today. And I had a damn good case. I will upload all this evidence at some point. There is 300 pages, so I need to put it into a document. I will let everybody see. I've taken many notes from the transcripts from the call today at the meeting, so I will write all that up. And we go back from there. So I am going to appeal, obviously, and I'm going to ask for it to be in person and a new judge. and I'm probably going to go to a higher court that I can ask for some sort of jury. But the whole case itself, what I was trying to ask the judge for was a full redress, that there is some criminal fraudulent activity going on here between these three corporations, that if it's removed from law, how can the magistrate supply me with a liability order? The magistrate don't have the jurisdiction. So it's all corrupt. I've unearthed a huge thing myself. This has all been around for a long, long time, but in myself, I've unearthed, how have I been asleep for so long? You know, how did I not know this growing up? How did my parents not know this? You know, it's one of those things that now I'm awake and attacking it, that we've got to do this together. You know, humanity now is on a fight of information and an information war. So you can probably hear it. I'm hyped up. I'm tired. I feel like I've not seen my family in a week, 2 weeks. I've been so busy trying to get this for the people, for you, for everybody, that we don't have to put up with this anymore. We don't have to put up with this crap anymore. Genuinely. And I wasn't afraid today. I actually found it at some points my voice was breaking. I was a little bit tearful because I felt the injustice was so awful. I was like, in a past life, I must have been hung. And now I'm like, how dare you? That's how I felt. It was so emotional, because I was like, how dare you blatantly lie and blatantly obliterate the law of our land and the law of the people. How dare you? And because I saw it with my own eyes, it really upset me. However, it's a huge lesson. I've got so much abundance today and gratitude for the lesson. We move on, we push on, we keep being us, and we keep dismantling the system. I tell you now, Jacob's come near that door, they'll have my wrath. They won't even, I'm that confident I would just shut my door. I'd never even open it. That's where I'm at with them. They